welcome to this special interview with the Attorney General of Guyana and Minister of Legal Affairs, the Honorable Mohammed Nandlall. We're here to unpack fact from fiction in an extradition case that has got the country talking. And there's been a lot of talk. So I wanted to start by asking the Attorney General of Guyana, you have an obligation, a duty to legally represent the citizens of Guyana, but also to ensure that our country abides by its international legal obligations. How do you balance between the two?
Thank you very much, Nazim, for inviting me to this studio to speak once again on the important issue of extradition. As you know, there is an extradition request that is being prosecuted in Guyana from the United States government to the government of Guyana. And it has, as you have correctly asserted, attracted great public commentary. How do I balance the competing interests? First of all, the interests are not really competing. On the one hand, the state of Guyana has international obligations on the treaties that it would have signed and on the international law and international practices. Among those international obligations is extradition. Guyana is part of a global community, and extradition is now an entrenched process that pervades the globe. And there are existing relations between and among nations to use this process in order to transport to different countries persons who are accused or charged with the commission of offenses across frontiers. Guyana has a duty as part of its global obligation to participate in the fight against transnational crimes, organized crimes, and criminality generally, to assist in this process. And Guyana has a track record of so doing. Countries that are engaged in this international process also have duties to ensure that while they are able to discharge their international obligations, they must at the same time ensure that the laws regulating extradition, and it is a statutory process, it's a legislative process, those laws must be complied with. They must be due process to the subjects of extradition. The constitutional rights of the citizens of the territory from which the extradition is being sought must be respected and complied with. And those are the general obligations that all countries engaged in the extradition process are expected to discharge. It is a process that is based upon international comity, reciprocity, and mutuality. And countries are expected to cooperate with each other in this international arrangement. And because, and that is why actually you have a trial taking place in one country, and the person comes from another country to stand trial in that country. When that request is made, it is normally accompanied by certain documents. The documents include an indictment issued by the judiciary of that foreign country and supported by a threshold of information upon which that indictment was issued. An indictment is issued by a judge and a grand jury. So there is a judicial adjudication to establish that these offenses are offenses in the in the requesting state, that there is a threshold of evidence and there is a threshold of materials to support this evidence, and then some duly authenticated acts and steps are required to be taken by the highest authorities in the country that is requesting the extradition. In the case of the United States, for example, no less an officer than the Secretary of State issues documents to support the extradition request, and no less an official than the Attorney General or his or her delegate issues duly authenticated documents to support the request for extradition. So it's at a judicial level and the highest political level of countries. When it comes here, it comes to the Foreign Affairs Ministry of Guyana, and then it is transmitted to the Home Affairs Minister.
By political, you mean diplomatic channels?
Diplomatic channels, but from these government to government
level, yes.
agents.
Yeah.
I say that to emphasize to you at what level these interactions and engagements take place. It's not no low-ranking public officer. Is the highest echelon of the governments that are engaged.
Yes.
Right? And then when it comes to the Home Affairs Minister in Guyana, there is an examination to see that there are a couple of things that must be complied with, and then a decision is made to extradite.
The perception is that that our courts here have to, well, let me ask it this way, what is the threshold of evidentiary material, or documentary material, that our courts, are they weighing it? What are they doing?
First of all, before I get to that question, extradition is not a complicated process. And the more the law evolved, the more relaxed the process has become. For example, all the case law authorities say very clearly, and case law authorities that emanate from all over the world, they say, for example, that the treaty must not be technically interpreted. It must not be interpreted like a legal instrument, but like a contract between two states. In other words, legalese must not complicate and unduly legalize the process of interpretation of the treaty. It must be interpreted in a manner to promote extradition, promote the objectives of extradition. That is to say, to bring fugitives to justice across international territories, across international boundaries. The same principles apply to extradition legislation, because normally there is a treaty and there is an accompanying legislation governing the process. The courts have said very clearly that those legislation must be interpreted broadly, generously, and purposively, with the intent of promoting the objectives of extradition. So that's the first point I want to make. So it's not a complicated legal process, simply because the trial is not going to take place in the country in which the extradition request is made. So the extradition request is made to Guyana. There is no trial that will take place in Guyana. The trial will take place overseas. There is no criminal charge in Guyana in relation to the extradition. So once you have no criminal charge to be adjudicated upon, There is no trial that will take place. There is no risk of any conviction in Guyana. These are all matters that will take place in the trial country.
Right.
And the trial country is the requesting country. So it is almost an administrative, quasi-judicial inquiry that has to be carried out. It is more procedural than substantive. It is to ensure that certain safeguards are met, that the offenses are extraditable, that there exists a treaty to extradite, that that treaty is in force, and that there is some material that satisfies the test for extradition. It's not a judicial inquiry, so to speak, where constitutional rights can be asserted in the way that I hear it being asserted in the public domain. And I hope we get to inquire into that a little.
I want to ask you about it. I mean, people are saying, well, he might have committed some of these offenses, or he's alleged to have committed, he's indicted in the United States on 11 criminal charges, right? And those are what's that, wire fraud, mail fraud, and all of these things. People are saying in the media in Guyana, in social media, the public, that these are not indictable offenses in Guyana. These are not criminal charges in Guyana. So this idea is floating around of, I think you call it dual criminality, where in order to extradite him, those laws must exist on our books in Guyana.
That is a tremendous misconception. Let me read. That's why I work with the Fugitive Offenders Act,
Okay.
which is the governing legislation on the matter. And there's a section in this act that speaks directly to what is an extraditable offense. So let me go through it, at least the relevant portions of the section.
Sure.
For the purposes of this act, an offense of which a person is accused or has been convicted in Guyana or any other Commonwealth country or treaty territory shall be an extraditable offense where the act or omission constituting the offense, however described, constitutes an offense and is punishable with death or imprisonment for life or a term of not less than 2 years under the law of Guyana and of the Commonwealth or treaty territory making the request to the government of Guyana for extradition.
Okay.
Is that not clear?
It's clear.
Now, it's an offense, however described. And there's another conditionality that it must carry a particular penalty. The offense that these persons are charged with in the United States are largely money laundering offenses. They are charged with transporting through the American system
Right.
gold, and in so doing they have committed a series of fraud using the American financial system to do so.
Right.
If those offenses were committed in Guyana, are they not chargeable in Guyana?
For sure. Yeah.
So that is why the law says, however described, using any process, whether it's mail, whether it's wire, whether it's the people's banking sector, whether it's their financial system, once you pass it through their system and you are committing a fraud in so doing. What is a fraud? You are gaining money by a dishonest means, and that dishonest means is unlawful. That money becomes unlawful. That money becomes money laundering money. Money laundering is always is dependent on a predicate offense. Once you commit an offense and you get unlawful proceeds, those proceeds automatically constitute money laundering. And these different fraud that are being committed are components of fraud themselves, and they're components of money laundering. Uttering forged and false documents, obtaining money by false pretenses. You're pretending this thing values so much, but it doesn't value so much. The ordinary public out there listening to me are aware of those offenses in Guyana.
Yeah.
They are fraud in its various kindred form. However you call fraud, whatever you call it, that's why the language of the law says, however described. Once it is an offense here and an offense there, that is all. We have an anti-money laundering, countering the financing of terrorism legislation here that creates nearly 100 money laundering offenses in all manner, shape, and form. We have an expansive statutory framework that criminalizes fraud in all its tenets. And in either or each of these elements of fraud or the money laundering, the penalty is more than 10 years. More than 2 years, sorry. And that is the minimum requirement. So the thing is, Nazim, I also hold the responsibility ministerially for Guyana's anti-money laundering framework. And this is a global network. And that is why money laundering now, the focus is directed mainly to transnational crimes, organized crimes, smuggling, money laundering, trafficking of cocaine, moving of illicit proceeds across borders. That is the new and modern focus of money laundering. And you're using an international financial system to do so. What you are doing, you're contaminating that international financial system. And when you do so, you are committing these offenses. The whole world operates in this global framework. You would recall, and the public would recall, when we were unable to pass certain bills in our country, when the opposition enjoyed a one-seat majority in relation to our AML-CFT international obligations, Guyana was blacklisted. International financial agencies refused to do business with Guyana. International banking relationship were severed. People had difficulty in getting biz transaction done on the international plane. Our businessmen can relate to that. CARICOM came here and virtually begged the opposition. The OAS issued statements calling upon the opposition to pass this. You know why? It is not a Guyana problem anymore. Once the international financial network is contaminated by illicit and organized criminal activity, then the whole world is contaminated. And that is what we got to get in our head. This is not a minor fraudulent offense about not declaring customs duties or not paying the right customs duties. This is the trade or the movement of gold. And you're using the American Customs Department that was basically forged and other documents apparently were put to. The American system was involved.
Yeah.
And that's why the Americans got involved. But it's bigger than that. It's a global system.
It's the integrity of the global system.
Global system.
If you compromise that integrity,
once you compromise that,
then the whole system collapses.
then the whole system is affected.
Yeah.
So the international nature of these transactions have to be appreciated. There is a great intent and effort to diminish the importance of it and make it national.
Yeah.
It is not national. It is international. I hear people say, but the Americans didn't lose any money.
Yeah.
It is not about that.
Yeah.
Money, look, you have cases where persons in Barbados are conspiring to send cocaine to the United States. The conspiracy was just completed. Not a gram of cocaine has left Barbados or entered America in relation to that. Yet the people were extradited.
Yeah.
The thing happened in Barbados. The conspiracy happened in Barbados. The cocaine was in Barbados. It didn't leave to go anywhere.
Wow.
They got cases out of, I read a case from Thailand, from Hong Kong actually. The conspiracy to export the cocaine to the US occurred in Thailand. The man traveled from Thailand to Hong Kong to receive payment, and he was nabbed in Hong Kong. Nothing reached America. It was just an agreement. And they were dragged to the United States. These cases reach as far as the Privy Council, and there were pronouncements to this effect, that this is no longer a localized matter. These are international crimes. They cross and transcend several international borders. They pollute a global financial framework and network that affects not a single country, but multiple countries.
Yeah.
So that characterization
Yes, right.
and the true nature of what these offenses are have to be appreciated. This is not murder or anything close to that. This is international crime. And I say murder because people consider that to be the extreme of offenses.
Yeah.
On the international stage, these types of offenses are even more serious than those homicide where one person dies. This here affects
Yeah.
the public at large. And when I say public, not the public in one country, but the global community.
And it also affects us because when that system collapses as a result, let's say we fail to uphold this extradition, right, is that we're sending a message to the international community that we no longer want to play by those rules.
That is exactly the signal that unfortunately was sent when our parliament, in which the opposition enjoyed a one-seat majority, voted down bills that were intended to meet our financial international obligations. That's exactly the position what the world took in relation to Guyana, that we are a pariah state. We are a state that is encouraging illicit crime, illicit proceeds, organized crime, money laundering, drug smuggling, because why else would you not want to comply with what every country in the world is complying with and what we have accepted by signing on to conventions as the acceptable behavior to which we will subscribe. You see, that is why I said this thing is based upon reciprocity, mutuality, and comity. And we all of us have phones now with capabilities to Google. Sometimes I see people writing on the comments that I use too much big words. But just type in those words.
Yeah.
I can't find a smaller word to explain.
How about comity? You can find a smaller word for that.
No, comity is five letters in that word. It's a very small word. It means respect among nations. Right?
Thank you.
It's as simple as that. So and mutuality means you do for me, I do for you.
Yeah.
Reciprocity means the same thing. You help each other. So when the papers come, they having been duly authenticated Meaning that it got a court stamp in America. It got the stamp of the prosecutor. It got the stamp of the judge. It got a summary of the evidence that they heard and they made a finding. Then the Attorney General of the country is putting his stamp. Then the Secretary of State is putting his stamp. When all those stamps and all those papers come to your country, you can't begin a process that would seek to impugn the validity of those documents. That's not what international comity is. That's not what reciprocity is. When we make requests for extradition, the same documents we send to the United States, we made requests for extradition for Marcus Bisram. We went through the same process. Magistrate, DPP, clerk of court, they put the stamp on. The Home Affairs Minister put her stamp on. The Foreign Affairs Minister put their stamp on. And when it went to America, the Americans acted upon it. They did what they had to do in America, and they sent Marcus Bisram home to stand trial for whatever the request was for. And I'm happy that many people can relate to that example. So it is not rocket science, and it's not a brain surgery, as I see people are projecting it to be. It's a simple process. And it is a process that is over 150 years old.
Yeah.
And almost all the legal issues that can possibly be raised have been raised and addressed by the courts.
Okay.
So I see people are saying that, there's a conspiracy and one man is saying that he didn't do anything and all sorts of things. Each extraditable offense, I'm reading the law again, however described, and they keep saying that, however described, meaning you can call it wire fraud in your country. Once it is illegal here, then it is extraditable, right? You can call it public nuisance if you want here, but once the conduct are similar and it is illegal here and it carries a penalty of a minimum of 2 years, it is extraditable. But let me get to the point I want to make. Each extraditable offense, however described, shall be deemed to include the offense of attempting or conspiring to commit, of aiding and abetting, counseling, commanding or procuring the commission of, or being an accessory before or after the fact of the offense. If you read those indictments, you will see the word conspiracy right through. So it includes all of that.
Right.
Right?
Right.
All of that extraditable offense includes the cohate, which is the complete offense, as well as the incohate. Incohate means there's an attempt or an agreement to commit. And if you are not the principal offender, but you played a secondary role, it caters for you as well. Aiding and abetting, counseling and commanding. That's what those words mean. And you can do it after the offense or before the offense. That is what accessory before the fact and accessory after the fact means. I say that, Nazim, for public consumption, so that, we can at least avoid the volume and volume of misinformation that I see being permeating, dominating and polluting our public spheres.
One that I want to ask you about before we get too far ahead of ourselves is the GRA withdrawing the charges against the Mohameds. People are saying, well, it wasn't political, why are you doing that now? Because there's a perception that if those charges were still on the books, that it would delay the speed with which the extradition might be carried out.
All right. I hear this issue of political being bandied about all the time. And I try to deal with it at the last sit-down I had on this matter. But let me try again from a different angle. As I said before, these charges have a date that they span from 2017 to 2024, right? Mm-hmm. On the documents themselves, they say that the investigation began since 2010, right? The two subjects of the extradition requests were not politicians when these things happened. The offense that is charged are not political in nature in any form or fashion. How the political argument came about? You know how it came about? It is after the sanctions came from the United States government and after it was clear that extradition requests were to follow, one of the subjects entered politics. It is he who made it political. Mm-hmm. And now he puts up politics as a shield. He made a conscious decision to get into politics knowing that this was coming. And then say that, so if there is any politicization, it is from the subject or subjects themselves. They introduced politics. It's they who entered into the politics after. Is that it? It was, and when you read up on what political driven extradition is that the requesting state, because that is where you're going to be prosecuted. You're not facing trial here. So it is there that the politics ought to be emanating. I don't know that they are involved in American politics. Mm-hmm. I don't know that they are engaged in any political process in the United States. It's the United States who is asking for them. So if political reason is to be advanced, the reason has to be associated with the United States government. Let them say what political relationship they have with the United States, what political cause they are opposed to in the United States. I don't know of any. Right? It is an accepted principle, a very self-evident and established principle of extradition law, that you have to adjust domestic arrangements to accommodate extradition. All countries are required to do it. Mm-hmm. And
is it part of this?
Yes, it's part of this. It's part of our treaty. I saw someone posted Article 4 of the treaty that expressly says that you have to adjust your domestic affairs. Because you can't proceed, though there are offenses in both countries, you can't proceed in both countries with the same or related offenses. These charges were filed, I think, before the extradition request came, right? And that's, I think that's in the public domain already. Yeah. The extradition request having come, you now have to adjust your domestic arrangements, because they cannot be prosecuted at the same time for the same type of offenses. But something I want to make clear, because I see this also being peddled in the public domain, that Guyana is giving up the taxes that would have been the subject of these charges. These charges are of a criminal nature. One can go to jail and you will still not recover the taxes. right? The penalties involved here is either treble the value of what you tried to evade, or a term of imprisonment. That's the penalty. So if you serve the term of imprisonment, the taxes go. So these charges would not have yielded the taxes anyhow. There is one thing that we must understand, is that the state's ability and power to recover taxes is second only to its power to protect and defend itself. You understand what I'm saying?
Interesting, yeah.
Its national interest is the only superriding power over a state's ability to collect taxes. Taxes are the lifeblood of a state. And every single country in the world have a panoply of powers to get taxes. So the state of Guyana has a repertoire of remedies available to ensure that taxes that are outstanding are paid through various legal processes. One doesn't have to jeopardize an extradition process to get that. And from all indication, the state will move in that direction. There's an assessment already done to the tune of 191 billion. That assessment has its own legal process of how those monies are going to be recovered. The other side has to participate if they wish, and that's a process that will travel a different road, and the law permits that. You see, that is why this sit down is important, to clarify for the public all these misleading and confusing views that are being peddled, some out of ignorance, obviously, but some, I believe, are deliberately done.
So next week, they return to a magistrate court, I think the 10th.
Yeah.
That's Tuesday or something. What is your assessment of where this goes? Some people are saying we're going to go to the High Court. That's where it's going to end up going. There's going to be constitutional challenge. There's going to be this and that.
Yes, I heard all of that, all of those arguments. So the other thing I want to make clear is that the prosecutors who are appearing in this matter are representing the government of the United States of America. That fact is not yet appreciated.
Well, no, let's stop there. That I've never heard that. That is the case?
That is the case.
The Jamaican lawyers, very seasoned veterans, are representing
the interest of the government of the United States of America, not Guyana. It's an American request that they are prosecuting. Well, you see, I spoke about mutuality and reciprocity. If they didn't come, the DPP of Guyana would have had to perform that function. That has been the practice in Guyana over the years.
Okay.
When we requested the extradition of Marcus Bisram, we didn't send lawyers in the United States. The United States Department of the Attorney Office represented the interest of Guyana in getting Bisram to come here. In the same way that the DPP of Guyana would have represented the American interest if these three lawyers were not selected to represent the U.S. interest. So that I want to be understood. In Trinidad, for example, different lawyers are retained to represent the U.S. interest.
I'm sure I read in the local media here that these lawyers are representing the government of Guyana.
No. They're representing the interest of the U.S. And the lawyers here, the defense lawyers, are representing the interest of the Mohameds, the subject of the... That's what I'm telling you. The state of Guyana, I don't know why people are dragging the government into this.
Right.
The state of Guyana got to ensure that the extradition process works in accordance with our treaty obligation on the one hand, our international obligation, and our legislative provisions. That is the state's duty in this matter.
So what?
That is why I saw the Vice President rightly putting up Marco Rubio's signature on a document.
Yeah.
Because the impression that is being conveyed, it is that these people are being persecuted by the government of Guyana for political reasons, when it has nothing to do with the government of Guyana. And I hope that I know I can't, I know I will never succeed in convincing the keyboard warriors who are representing a political cause. I will not be able to convince them because they have their own narrative that they're pushing. But I'm speaking the law, and I'm trying to address the minds of objective listeners and viewers.
I have two more questions. One is, what happens now? Does this process illegally, where do we go from here?
You mean legally?
Yeah, legally.
I thought you said illegally.
No, legally. Where do we go from here?
Okay. So, the magistrate has already ordered disclosures. When the lawyers appear in court, those issues will be addressed. The defense, or the lawyers who are appearing for the subject persons, have to be given the documents because they have to study them and so on. So that process will undergo, and then the hearing of the committal proceedings will begin. I want to address one issue because a lot of, there's a great lawyer named Rex McKay, senior counsel. He's no longer with us, unfortunately. And he had a term to describe persons who like to talk law but are not qualified. And I'm not being facetious and disrespectful, but we used to call them bush lawyers. We have a lot in this country, and even some lawyers who have certification to establish that they are lawyers. Sometimes they remind me of bush lawyers, and I say so with respect. So I heard all manner of constitutional violations are being alleged, and the constitutional process will be invoked. I want to make something very clear. The Constitution accords rights and freedoms to citizens and non-citizens of Guyana. But we have to examine what those rights and freedoms are. The ones that are being bandied about here, that are being violated, have no application to these proceedings. This extradition proceedings, by all the judicial pronouncements, by all the courts in the world, are described as sui generis. It's of a special kind. They're not criminal proceedings, so to speak. It's an inquiry to determine a couple of objectives, and then the criminal process will begin and end in the country where the trial is fixed. So our Constitution speaks to a right to a fair trial, a right to be afforded a hearing within reasonable time, a right to be presumed innocent. But those rights relate to persons who are charged for a criminal offense and who are going to be tried here for a criminal offense. These persons are not charged in these extradition proceedings with any criminal offense. They are not going to be tried here in relation to those extradition proceedings for a criminal offense. And therefore, and our Constitution also makes express reference. Those very provisions, they make express reference to extradition proceedings. They say you're entitled to your liberty, yes. And they have a number of exceptions. For example, you can be deprived of your liberty to serve a sentence in a court. You can be deprived of your liberty if you are remanded. You can be deprived of your liberty for an extradition process. You know why that is specifically there? Because it is not a sentence of a court. Because you have not been tried and convicted. It's a special process recognized by the Constitution that can deprive you of your liberty. It's not criminal. You don't stand a chance of being convicted. Your innocence don't have to be asserted. It's not that type of hearing. And that is why it is specially catered for in the freedom of movement and freedom of liberty provisions in the Constitution. Because it's uniquely recognized. If you're in, you have to be in custody. But you're not in custody to be extradited. But you're not in custody at the end of the committal proceedings I'm speaking about, right? You have to be in custody to leave. But when you are leaving there, you're not under an order of court that has found you guilty. You're not under a remand while you're facing a charge in Guyana because you have not been charged. And because of the uniqueness of your status as an extraditee, the Constitution had to make a special provision for you. Right? These things have to be appreciated. So, a big spectacle is being made of what is a simple process. Of course, lawyers have tried, not only in Guyana, all over. First of all, the succession rate of extradition is very, very, very high.
I want to ask you about that. That's my last question.
Okay.
So a lot of cases have taken place in Guyana. If this was John Doe, nobody would have paid attention to it. It would have gone through the courts. It'll happen, maybe an article or two. But this is a high-profile case. So tell me what precedent, what cases have come before this, like this, or similar in nature, that have taken place. You once said it was routine that these things happen in Guyana.
We have cases in Guyana that traveled all the way to our Court of Appeal on extradition. And a multiplicity of issues that I'm hearing being raised now in the public domain have already been determined by our court. Whether the offenses are extraditable, whether the treaty makes a provision for certain things that they say the treaty should make provision for, all manner of things, whether constitutional rights are violated.
So we have a mountain of case law.
We have a mountain of cases. Recently, there was a beautiful decision given under the previous administration. Comrade Ramjatan, as the minister, issued the authority to proceed. And the person was extradited to the US, and they had proceedings in the court, and we have two beautiful written judgments from two judges who are now Court of Appeal judges. One is the current Chief Justice, Ravindra Singh, and one is Justice Juan Barlow. Some of the lawyers who are in this case have appeared in that case. And they raised all types of objections. All were rejected. So there is no paucity of case law authorities in Guyana. Go across to the Caribbean, Trinidad is possibly, and Jamaica are the extradition capitals of the Caribbean. You have multiple cases traveling through the whole system all the way to the Privy Council on these matters. Barbados have several, including pronouncements from the Caribbean Court of Justice on these matters. The Eastern Caribbean have many, many cases. In fact, what the Privy Council in particular have said is that you don't interfere with the committal process by interjecting technical, procedural, or constitutional challenges. They discourage that and they have knocked them out. They say wait until the magistrate makes a ruling and follow the act. You see, the act creates, the thing is so unique that the legislation makes its own procedural path in the legislation. After the order is made, a certain time has to expire to see whether the subject persons are offered an opportunity to challenge the magistrate. After she makes her decision, however, to the High Court. And there is a challenge beyond that too. So the legislation outlines its own challenge. It doesn't contemplate whimsical and frivolous challenges through all kind of methodologies. And the authorities, as I said, are now legion on these matters. They are plentiful. And they have said, look, don't try to interfere with the process. You'll get your chance. Wait till the process is completed in the magistrate court, then challenge. And that's why almost every single attempt to interfere with the process as it is continuing in the magistrate's court, or to stop that process by introducing some hiatus to go up to another court, has failed. Almost every attempt that I know has failed. So it's not a complicated process. The magistrate has not a heavy burden. The prosecution doesn't have to establish much. The defense doesn't have much to do other than to ensure that the law, the safeguards that the law provides are accorded to them, that the provisions of the treaty are observed, and when the process, as it came through the government, it goes back to the government for the final rites to be performed, for the extradition to take place. That's the process.
Yeah.
Once it completes this judicial journey, it ends back at the desk of the Minister of Home Affairs to make the final determination.
Minister Nandlall, it's always wonderful to talk to you. I learned so much when I talk to you, and this discussion is no exception. Thank you very much.
You're welcome. Thank you.